Welcome back to Legal Alternative Podcast with me, Sam Pawson, joined as ever by Nils. Nils, how are you?
Very good, Sam. Yourself?
Yeah, plodding on for a quite rainy November day and time of recording, but no, all good. As always, very busy in the legal world and more updates to share. Nils is without notes, so I'm very eager for this update. So I think you're going first. So yeah, hand over to you.
I've been talking about immigration a lot.
You have.
So I would depart from that. And I would talk about the equally exciting health and safety breaches.
Yeah, very exciting.
And been dealing with some really big cases at the moment in terms of both profile and content, in terms of the health and safety executive prosecuting individuals, prosecuting companies for breaches. What I wanted to talk about was if you're ever unfortunate enough to find yourself in that position, what should you do? The obvious thing is to call us.
Yeah.
And that's absolutely critical. You've got to get a lawyer involved. These are pretty complex cases, but obviously we advise that for everything that we ever talk about. It's really critical that clients who are in that situation understand that there's going to be a deep dive into the company. And I try and break these cases down into three elements. Something's gone wrong.
Yeah.
The HSE don't tend to prosecute unless they know they're going to win. Their conviction success rate is, I don't have the stats to hand, but it's in the 90%.
Yeah.
So that they're hugely efficient at working out which cases they can win and which cases they can't. Not criticising them for that. Sensible way to actually approach these things. So something's gone wrong. Correct the wrong. If it is somebody has chopped their hand off because there wasn't a guard on the machine, put the guard on the machine and make sure your paperwork's in order, your risk assessments, your safe working procedures, and that your health and safety is taken to the next level for when you're actually in court. But you've also got to demonstrate more than that. The financial penalties for health and safety breaches can be big. So we're going to have to paint a financial picture. And part of that financial picture might be how well the company's doing, or it might be how well the company isn't doing, whichever, or it might be somewhere in the middle. Whichever that is, we need an explanation for where the company is. So technically, you're only required to submit 3 years' accounts. That isn't going to be enough. We need to help the court understand what those finances mean. So in court recently, I was expecting to go in front of a district judge because these are quite often complex cases. It was actually in front of a bench of lay magistrates. We've got to be able to explain to those lay magistrates what the finances of the company mean for any fine that they levy. The other thing is talk about the company and the stuff that you do outside of your core business. So it might be some companies have a community arm. It might be that you're a company that does charitable work. Those things are impacted. If you are fined £1 million for a health and safety breach and can't support the George's Crypt, any of the charities that we support, for example, the court need to know about that. So it's about painting this quite wide picture of the company, and then the court obviously decides what it's going to do. But without that key prep, you're not going to be as good a shape as you can be.
I know we do mock health and safety trials every year, and that second point in particular, and these are all based on real cases. The issue where the company has a health and safety breach and then doesn't do anything about it 2 years is so common. You think it would be self-evident whether they think they're going to incriminate themselves by then fixing a problem. But as you say, when you know you was going to lose, you have to fix the problem. This is about mitigation. So.
Absolutely. And I think cases fall into two camps, where an employee is doing something that they shouldn't have been doing, but you never told them not to do it, or they're doing something that they should have been doing and have got injured. Either of those scenarios, you've got to take corrective action.
Perfect. Sage advice as always. No, I'm going to talk a quick case. As I mentioned last week, I was still awaiting some further briefings on the employment rights bill. Some commentary this week from Peter Carl, the business minister. I think potentially being the starting of a watering down process
already.
There's commentary that they are listening to the CBI and other businesses and the concerns and the cost to potential business. There is still commitment from the government as of recording today that we're not going to see any watering down. As I say, we potentially will, but we will continue to report as and when we hear anything. So what I wanted to focus on today, just a quick case law judgment. And I want to talk about appeals. And we talk a lot on these podcasts about obviously finding of facts, disciplinaries. And I think the appeal is often lost. But very important point. The case itself, quickly, it's involving Wetherspoons. So it's a claimant, Mr. Davis versus Wetherspoons. Got some press attention, this one. The kind of clickbait headline was about employee essentially dismissed for eating halloumi fries. So this was a big halloumi fries judgment. So real brief facts of the case, Nils. So Wetherspoons offered a staff discount policy where they got 50% off food and drink while eating it on site. So the policy said 50% off as long as you eat it on site, as obviously your lunch or your food on the day. The policy said that any misuse of that was deemed to be gross misconduct, and there was a zero tolerance approach to that. Facts of the case say the bar shift leader, the claimant in question, applied a 50% to the discount, but for the halloumi fries in question that a colleague took home with him. So this was a takeaway, not something on site. This investigation into the matter, disciplinary hearing, dismissal on the basis of gross misconduct, zero tolerance approach not being applied, policy being followed, dismissal. Employee appealed his dismissal, and the appeal chair upheld the dismissal, but actually applied different reasons for doing so. He found that the employee mistakenly applied a discount and they'd mismanaged their shift by not properly looking into this. So this was not an intentional, this was something that was a mismanaged process rather than a deliberate act. This then goes to a tribunal who holds that given the appeal findings that this wasn't dishonesty, that he wasn't deliberately doing that a finding of gross misconduct was inappropriate.
Yep, agreed.
And therefore the dismissal was unfair. What that critically shows is the importance of appeal and what an appeal really is. Generally, appeal should be a review of the immediate decision. What the appeal officer has done here is not done that. They've almost reheard the matter and substituted their own views, which has actually caused the company problems. I would probably suspect if they would have reviewed it and said, the decision was, then the decision probably at tribunal would have remained that the dismissal was fair. Or if the appeal is appropriate and the appeal officer really thought that this was a misunderstanding in the original case, then the dismissal shouldn't have happened. Yeah. So it's a clear case of either an appeal officer not understanding his remit, or he understood his remit and he's therefore not substituted the appropriate decision because he doesn't understand the law. So interesting in I thought case, just alert that the importance of appeal, because I think there is views by claimant lawyers, there's views by members of the public that appeals are pointless. They're just tick the box exercises. There may be some sympathy in that opinion, but this case clearly shows it's not. And why they have a clear, distinct part of that disciplinary process. We've got an investigation, we've got disciplinary and an appeal, all distinct parts of the process. And if you get one of those potentially wrong, you're looking, obviously, at unfair dismissal finding. Yeah. So just thought it was a good one to quickly alert to something. It's a good way of getting our message home, which is, don't take these for granted. Look into these as, separate important parts of that disciplinary process.
Presumably, though, if different logic had been applied which still related to misconduct, that would have been fine.
I think so. Yeah. It's the key. It's the
shift.
It's the shift in the threshold of gross misconduct. Yeah. The fine of the tribunal, without the dishonesty that the gross misconduct was not within the band of reasonable responses, and that some form of lower sanction would have been suitable. We always talk about this band of reasonable responses, the threshold for gross misconduct being quite high, and without this deliberate dishonesty, you can't meet that threshold.
Exactly. So, and I think that's almost saying it's gross misconduct because of performance. Yeah, just a total. It's a very basic mistake, actually. Isn't it?
Very basic mistake. You would hope that who are getting advice, as always, with our dear friends in Wetherspoons. Well, we don't know what that advice is, but because they come up a few times. I think this is not my first Wetherspoons case, if I put it politely. So interesting as always. Quick updates for us today. I don't think I have nothing out of the office to report, Nils, unless you do. 2 relatively brief updates, but really important things for the listeners to hear.
Yeah, good stuff. Good stuff. Enjoyed that.
Yeah, absolutely. Back next week, as I say. Still, we'll be on the pulse for any major changes. Our time recording in our mock tribunal is Thursday, so I think lots to talk about, kind of fallout from that, and critical cases to bring with you. So it's goodbye for me.
And for me.